The courtroom is called to order. The judge announces the case, the state of Texas versus Gracie Segundo. The defendant, a mother of 4, stands quietly beside her attorney. The charge, assault causing serious bodily injury. The plea bargain recommends 7 years in prison, but with the possibility of probation. Both sides confirm they've reviewed the pre-sentence report. Small errors are noted, dates, minor details, but the tension in the room says it all. What's about to unfold is not about paperwork. It's about mercy versus consequence.
It's calling 2022 CR 10214B, State of Texas versus Gracie Segundo. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Javier Oliva and Bradley Bellis for the defendant.
Are you Gracie Segundo?
Yes, ma'am.
All right. According to the plea bargaining agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine. The state is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes,
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report that we wanted to bring to your attention.
Yes.
So it lists the offense date as, I believe, November 16th of 2021, when in reality, the offense date that's on the indictment is October 16th of 2021.
All right.
And it lists that in the criminal history. There's an assault that was in the criminal history that it makes it seem as if they're two separate offense dates.
Okay.
And then I think in the towards the back of the actual statement itself that Ms. Segundo gave, there's a portion where it's talking about the co-defendant and that he's charged with ag assault deadly weapon. It's assault SBI. It's the same offense.
Okay.
We just wanted to make sure you were aware.
All right. And the court is also in receipt of victim impact statement. And the court reviewed that without.
The judge turns to clarify a sensitive matter. The victim in this case, Rebecca Martinez, isn't just anyone. She's a sitting judge on the 4th Court of Appeals. The courtroom holds its breath. The presiding judge declares, calmly but firmly, that her personal acquaintance with the victim will not affect the outcome. She's never been to dinner at my house, the judge says, and my decision will not be impacted by knowing her. A clear line is drawn between friendship and justice.
Without objections from the state or defense, is that correct?
Yes, Your Honor.
Yes, Your Honor.
And the court is also in receipt of letters that defense presented on behalf of the accused. And there were no objections to the court reading those letters. Is that correct, state and defense?
No objection, state judge.
All right. So the court has reviewed all of those documents.
Your Honor, I also raised that part of the agreement of coming back today was that the misdemeanor occurred on the same day of this alleged date. Was to be taken into consideration with CC County Court 4 case 969-3701.
Yes. And the court does have that as a part of the plea bargaining agreement.
And Judge, just to kind of expand on that, I believe as an additional part of the plea agreement was that she was to take responsibility for what happened as a part of the TIC.
Yes. Okay. All right. So my understanding, the complainant in this case is Rebecca Martinez?
Yes.
All right. And is that the Rebecca Martinez who's on the 4th court?
Yes, Judge.
Yes, sir.
All right.
President courtroom.
So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues. And when I see her, I say hello.
Both sides confirm no witnesses will be called for the state. The defense prepares to plead directly for leniency. Before they begin, the judge requires Segundo to swear in. Nervous but steady, she raises her right hand. A small misdemeanor case linked to the same incident must also be addressed. At first, she pleads no contest. The judge shakes his head. You must take full responsibility. After a moment, she changes her plea, guilty. The court accepts it, signaling the start of what may be her last chance to prove remorse.
She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State,
No, Your Honor.
defense.
Your Honor, I have all the confidence that it was fair and right in this case, so no objection.
All right. So are there any witnesses that anyone wishes to present? State?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant,
All
which the court has already noted that they read.
Yes. Defense, any witnesses?
Your Honor, other than my plea to you and our arguments to you before considering sentencing in this matter, I will be speaking and Ms. Segundo may say a couple of words. And Ms. Segundo's parents are present in support of her today. I can stand with Mr. is standing here in support of her today.
All right. Thank you.
They will not be speaking.
All right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Gracie Segunda.
And with regards to County Court Cause number 6933701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign.
The prosecution takes the floor. The state's attorney is concise but firm. He describes a violent altercation that left the victim seriously injured, a senseless act that didn't need to happen. He stresses that the victim's life has been forever changed by this assault. For that reason, the state opposes deferred adjudication and asks instead for probation with conviction. His tone is controlled, but his words carry weight. This was serious. Someone must be held accountable.
That I don't know if you want to discuss that with her.
We'll go ahead and proceed with a guilty plea, Your Honor.
All right. So the County Court Cause number 6933701, how do you plead to that?
Guilty.
All right. And state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number? All right. So the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. It was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that day forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense?
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Segundo, I think, has demonstrated a respect not only to others, but to...
Then the defense begins its plea. Her attorney speaks passionately. One incident cannot define a person for the rest of their life, he says. He paints Segundo as a loving mother, devoted worker, and caretaker of animals. 32 letters of support from friends, family, and community members describe her as kind, gentle, and selfless. She's a single mother raising 4 children, he pleads. A conviction would destroy her ability to work, to support her family, to simply be their mother.
to life and to animals and in her work and her career and taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. and she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA, and a felon cannot be associated with children and be around them in school activities. This would drastically impair her ability to be a mother to her children. And so she's really fighting to be able to continue to provide the love and the support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest.
The defense continues with conviction. Segundo has complied with every order for 2 years since the incident. She's attended every court date, traveled hundreds of miles, and shown respect to the process. She doesn't deny what happened, her lawyer admits. It was a moment of chaos, not malice. A reaction, not intent. He argues the fight began when her friend was struck. She intervened, trying to help, and things spiraled out of control. His voice softens. Judge, she's willing to do whatever this court requires. Please give her that chance.
She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think that you're not going to be subject to a conviction, but in actuality, you are subject to all the conditions and behavior for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought.
The judge listens carefully. He reminds the room of something crucial. In this courtroom, everyone is a human being. Titles don't matter. Then, he poses a question that cuts to the heart of the case. How does an elevator disagreement turn into a brawl? Segundo looks down. It happened so fast, she says. Someone hit me, and I reacted. Her words are quiet but heavy. The judge presses further, trying to piece together the moment when control was lost.
It was just something in her reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agree to repay that. We will work hard every day to pay that back. But in this working community and in Houston and San Antonio, mothers every day have challenges. And we regret that this happened. And I know that she sincerely has nothing personal against Ms. Martinez or her husband. She wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition, so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
Nervous.
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively.
The defense explains the setting: a crowded post-game elevator during COVID restrictions, limited capacity. Tensions flared when people refused to get off. Words became shouts. A shove. Then a fight. Segundo's attorney insists she didn't go looking for violence. She was trying to pull her friend away, he says. She was struck and reacted in fear. But even as he speaks, the prosecution objects, reminding the court that the victim's injuries were severe and that a civil lawsuit is now pending for millions in damages.
And not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI report, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I don't know, I couldn't tell you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator.
Mhm.
Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity, people need to get off or more people can't come on, how that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight and then you decided to get involved in that.
The judge turns his attention back to Segundo. "Why didn't you just get off the elevator?" he asks. She hesitates. "We had already waited for 2 elevators," she says. "We didn't want to be the ones to get off." The judge exhales, frustration under his calm voice. "So, this was over an elevator?" The courtroom is silent. Even her attorney can't escape the truth. This was a moment of pride turned to violence.
That fight.
I went to go and try and pull my friend away, and then I don't know, it was just a bunch of people, and somebody hit me, and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator, they were asked that there was too many in the elevator, and then people had to decide who's getting off, and they asked who she was with, another man and another person, to get off the elevator. That person said, "I want to talk to your supervisor." That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. she came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That's stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And in the process of that was struck, and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's why we're here 2 years later doing that. And in addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden of proof, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit right here. You want to see it, Judge? It's public record.
I would object just because relevance.
So lawsuits and filed.
The state calls a final witness, David Martinez, the victim's husband. He recounts what happened, the confrontation at the elevator doors, the heated words, and the sudden chaos. He describes being knocked to the ground, his wife bloodied and dazed. She couldn't defend herself, he says softly. The defense cross-examines. Was Segundo defending someone else? Martinez can't say for sure, but his voice breaks when he describes seeing his wife in pain. The room falls quiet again.
On the city court, that's a copy from the courthouse.
All right. Unless there are some facts that are listed in the
It pleads
lawsuit.
the whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will.
It does not, Judge.
All right. So,
Just to let you know, there is a civil suit.
all right, then the objection will be sustained. All right. Anything else from either side?
No, Your Honor.
No.
All right. I've read your letters that were presented, and it appears that, other than this one incident, you're a great person. But sometimes sentencing, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
You were on the elevator.
Your Honor, the elevator's doors open. They entered into the elevator and they were asked, there were too many in the elevator, and the elevator operator asked people to voluntarily get off.
All right. So there were already people on the elevator. Then you got on the elevator and you were asked to get out.
Us just walked in at once.
All right.
And
And then you were asked to leave.
then they said we need people to get on.
All right. So why didn't you just get off the elevator? That's what I don't know.
Closing arguments begin. The defense compares the event to offsetting penalties in sports, a momentary clash with no winners. She didn't start this, he says. She reacted. And she's lived with regret every day since. He urges the judge to see her not as a felon, but as a mother, a worker, a human being who made one mistake. Give her probation, he pleads. Give her the chance to prove herself.
Understand.
You didn't decide that.
No.
She didn't decide that. It was a person that she was with, Your Honor, who is a defendant in the case that's in another court.
So my question is, though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong, people were on the elevator. They had not met maybe their 7-person capacity. And then you and your group come on, and because of the number in your group, they've exceeded their 7-person capacity. And then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator? That's what I don't understand. Even if you're with somebody in your party who says, I'm not getting off the elevator, why didn't you just get off and I'll wait for the next elevator? I'll take the stairs. I don't understand.
We had already gotten off 2 floors, so we said like we've been waiting, but we didn't want to be the ones to get out.
And was alcohol involved, or people just don't want to take
It
the
was after a
stairs?
football game, Judge.
Estate, does anybody want to? I know the complainants are here. Do they want to
No,
say anything to the court?
no.
Okay.
Oh, Your Honor, may I have one moment?
Yes.
Your Honor, I'm going to call case question.
Okay.
Your Honor, he's not a victim in this case.
The prosecutor stands once more,
Calm.
unyielding. Yes, she wasn't the instigator, he says. But she made the choice to escalate. The victim still suffers today because of that choice. He reminds the court that the entire incident began over something trivial, a dispute that could have been avoided with a little patience. That's what makes it so tragic, he says. A few seconds of anger changed lives forever.
Case. Why would he come to?
I mean, we'll see what he has to say. I don't know if he's a relevant witness or not, but if he were present at the scene.
You know, I would think that the person involved is the one who's, in this case, is the one that would need to address it. He's had his day in court. He has spoken before the court. I don't see why he needs to speak in this case at sentencing.
All right. You can call your witness.
State calls David Martinez.
All right.
Your Honor.
You're welcome. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. You can lower your hand if you'll state your name for the record.
David Martinez.
All right. State.
Mr. Martinez, from your memory, what occurred on that day?
On that day, we were in line to get into the elevator. The capacity of the elevator, of course, as I mentioned, was 18. But because of the COVID era, there was an elevator attendant there. She said only 8 could be allowed in. We were 3 couples and 2 children, which were a total of 8. As we walked in, we were already in the elevator. They decided to come in behind us. The elevator attendant told them they need to step out. It's full. They had been intoxicated. Her friend.
Objection, speculation.
Overruled.
No, they were
No. Yeah. Here's the thing. Where you cannot address the attorneys. Once an objection is, no problem. Once the objection is raised, just stop speaking. I'll make a ruling on the objection. And then I'll let you know if you can continue or not, if you have a question about that. That objection will be overruled.
He came in, stood at the door, prevented the door from closing, began to.
Objection, Your Honor. I just asked for clarification from the ones. I don't know who he is.
Now, all eyes return to the bench. The judge weighs the evidence, the pain of the victim, the remorse of the defendant, and the humanity of both. He acknowledges the letters of support, the cooperation, the tears. Sometimes sentencing, he says, isn't just about punishment. It's about whether a person can change. He leans forward. I believe you're sorry, he tells Segundo. But the victim's injuries are real, and they will last.
Which he are you speaking about, sir?
Her partner, there was 2 gentlemen, which was the initial one that started arguing with us, and her partner that she was mentioning that walked in, and they were not. We were already in the elevator already when they decided to block the door from closing. Can't recall the individual's name, but it was a younger gentleman that was with her. He proceeded to argue with the elevator attendant about, letting them in or not, that it was BS, that they cannot be let in because there was a lot of room. And she told him they had to leave. He continued to argue with her, and he said that he wanted to talk to her supervisor. And she says, if that's the case, she shut off the elevator. And that's when words were back and forth. They continued berating us. She was cussing like a sailor, as well as the other ones. We kept quiet, and they started again arguing with us. We stayed in there. The kids were already getting terrified with what was going on. They started crying, and they continued with their vulgar language. And I just told them one time, that's it. F you. The gentleman that was with him got upset. He literally from the outside ran into the elevator, knocked us all over, and assaulted all of us in there. I grabbed him and I pushed him out. It was not the individual that she says was in there. It was the other individual that was with him that probably hosted them to the game. And he and I went outside. And after that, what?
From there, sir, is that where everything happened?
Correct.
Pass it with this judge.
Any questions?
Mr. Martinez, I'll just start right from leaving the elevator. So by the time that you set foot out of the elevator, you're in the middle of a physical altercation, is that right?
Yes, while I was on the ground.
Okay. How much were you able to perceive about what was happening around you while you were in the middle of that?
Well, I was
altercation?
on
So
the
if you
ground.
let me finish my question.
It's,
100%.
So my question was, how much were you able to perceive about what was going on around you during the middle of that physical altercation?
And I was not able to see when I was in the ground what was taking place after that.
Okay, and we can agree that the incident in question, the basis of this criminal case here today, is something that happened during the middle of your physical altercation, right?
While I was on the ground, yes, and then afterward, I did get up and partially saw my wife on the ground with a bloody nose. She was in a daze, and I asked her what happened, and I told her that she got hit. She said, "Yeah, I got hit multiple times." And I said, "Well, why didn't you defend yourself?" She says, "I couldn't because I was being held down."
Can you say for certainty whether or not Mrs. Segundo was acting in defense of another whenever she got involved in this incident?
I'm going to object to relevance.
all right, that'll be overruled. You can answer the question if you know.
I can't say that, but
Finally, the verdict is delivered. The judge finds Segundo guilty of assault causing serious bodily injury, but he suspends her 7-year prison sentence, granting 5 years of probation. A $500 fine, community service, restitution, and strict conditions follow. No contact with the victims, no work with minors, regular reporting, proof of employment. I don't see this as an anger issue, the judge says. I see it as a single, tragic aberration.